Thank you, Mustafiz Bhai, for the very generous introduction. Honorable Justices of the Supreme Court of Bangladesh, learned members of the Bar, distinguished guests and panelists, ladies and gentlemen, a very good morning to you all. I have been tasked with presenting the keynote of this session on doing business in Bangladesh, which aims to sketch the legal and regulatory environment impacting businesses. I hope this sketch is able to draw out sharper insights from our panelists and also set the tone for the deliberations of the day. Before I go into the legal and regulatory environment, I would just take a few minutes to talk about how Bangladesh is a success story. We have been called a development paradox and also the new Asian tiger. On macroeconomic parameters, we have graduated from a least developed country status to a developing country status with a per capita income of $1,600. We have had a consistent GDP growth of more than 6% over the last 5 years. Poverty has been halved and stands at 24%. We have a high foreign currency reserve of 32 billion. 80% of our export earnings come from the RMG sector, and what is even more significant is that this sector has been the sole driving force of female employment and female empowerment in Bangladesh. For the first time, we are in the top 100 of the global competitiveness ranking by the World Economic Forum. We are projected to be one of the top 3 fastest growing economies by 2050. Our digital and technology transformation has also contributed to where we are today. We have over 143 million mobile users and 80 million internet clients. Bangladesh adults have carried out 34% transactions over digital mediums as opposed to a South Asian average of 27%. We have had significant financial inclusion led by mobile financial services. On the infrastructure front, we have had significant strides. We have 40 power plants with an installed capacity of more than 16,000 megawatts. We now have a 4-lane Dhaka-Chittagong highway, a 3rd seaport at Paira. Our Podda Bridge is 50% complete. We have a lot to be proud of and hopeful for. From industries in the consumer business to telecom to technology, Bangladesh holds huge potential and prospects. To unlock this potential, what has consistently been identified as priorities are increased private investment, healthy capital markets, sustainable revenue generation, and a shift in our workforce skills. Yet, on World Bank's Doing Ease of Business in Bangladesh, we have actually slipped down a notch. The doing business reports have now become a guiding indicator of what the legal and regulatory environment is in a particular country. Bangladesh is ranked 177th out of 190 countries. It takes more than a year to get a utility connection, almost a year to register property in Bangladesh, which is actually double the South Asian average, and almost 4 years to enforce a contract at the court of first instance, which is for us the district courts. And the cost of that enforcement is 66% of the contract value. So while we have a bright future to look forward to, I will illustrate the state of regulatory affairs with a very few basic examples of the difficulties businesses face in their day-to-day operations. Example 1. A company which has foreign shareholders as shareholder directors often need to transfer the shares when one such foreign national is exiting the company or leaving the country. The Registrar of Joint Stock Companies, which is responsible for effecting and registering the share transfers, now require personal attendance of the transferor, which is a fair requirement to curb fraud, to curb fraudulent transfers. However, in cases where an individual has already left Bangladesh, they have been unwilling as well as reluctant to accept transfer documents authenticated by the consulates abroad. As a result, I am aware of companies where dividend remittances, critical transactions with banks, royalty repatriation, dividend repatriation has been held up for almost 2 years, simply because the RJSC, which is the primary regulator for registering share transfers, does not appreciate the documentation requirements and also insists on physical presence of the transferors in cases where the national is non-Bangladeshi. This in itself is enough to discourage foreign investors for whom appointing foreign nationals transferring shares is a very common thing. As many of you would know, that there is a licensing scheme operated by our national standards body, which is the Bangladesh Standards and Testing Institution. This licensing scheme is mandatory for 154 products, of which there are consumer products like toilet soap, shampoos, edible oils, as well as electronic, textiles, and jute products. It is also mandatory for products imported into Bangladesh, including milk powder, chips, crackers, and toffees, just to name a few. The licensing scheme operated by the Bangladesh Standards and Testing Institution is intended to ensure quality for the products being sold in the domestic market of Bangladesh. I would like to tell you the story of a renowned chocolate and confectionery manufacturer that has shied away from investing in Bangladesh when it realized that the national quality standards were below its global product standards. The manufacturer made a request to the BSTI to review its national standards and align it with comparable global standards or comparable standards of other countries in South Asia or the Asia Pacific region. This request was met with great reluctance and hesitation, and finally the request was not entertained. This quality standard alone was the barrier which dissuaded investment in Bangladesh by the global manufacturer. In a number of other cases, manufacturers of fast-moving consumer goods were discouraged and in fact actively hindered from introducing new category of products in Bangladesh simply because our standards institution refused to frame product standards and rather termed those products as unsafe for the Bangladesh market, even though they are being sold globally and marketed in many other countries, including Western markets as well as other Asian countries. I cite these examples on a no-name basis for obvious reasons. This form of regulatory discretion is not only preventing innovation and technology transfer, but this will also prejudice Bangladeshi manufacturers trying to tap export markets because of the lack of reciprocity or comparable licensing quality regimes. In a country with a population of 160 million people, we are looking at 160 million consumers and a large potential for technology transfer, improving our consumer goods production sector, which is being untapped simply because of regulatory reluctance and in often cases capability issue on terms of knowledge management. The third example involves a global business process outsourcing and consultancy firm which had to wind up its business in Bangladesh simply because our labor law regime is not familiar with outsourcing. If we look at the examples of India, in Hyderabad and Bangalore, where business process outsourcing has been one of the key drivers of development, Bangladesh needs to look at the fourth industrial revolution, transform its workforce skills, and what we need is a regulatory environment at the very basic, feasible employment environment which will take account of this outsourcing regime and facilitate our strides in the service industry. What we are looking at is inconsistency, lack of certainty, and lack of clarity. Just last year, there was a confusion of whether 60 services provided by our port authorities during import and export clearances were VATable services or not. There was conflicting views issued by the National Board of Revenue as well as the Chittagong Port Authority. In Bangladesh, prices are regulated through a a price approval mechanism under our Value Added Tax Act. The higher judiciary has witnessed large number of litigation on account of price approval cases. The price approval cases often see the revenue authorities revising prices of manufacturers upwards even without any consistent principle or accounting basis. Another dangerous pattern of revenue collection that has emerged is retrospective imposition of value-added tax and VAT in cases where there was no revenue fraud committed, with particular targeting of cases involving multinational companies. As we all know, the telecom industry has seen most of such nuances on both the VATability and licensing front. The transfer pricing regulations were introduced in Bangladesh in 2012, and in 2019, the transfer pricing audits are about to commence by the tax authorities. These are meant to apply to all related party transactions or associated enterprises, but the tax authorities have already indicated that MNCs would be under the lens, as they believe there are enough scope for collecting more taxes from MNCs. This actually defeats the purpose of having a level playing field and a consistent VAT and revenue framework for all businesses in Bangladesh. While there is a proclivity for regulation or higher regulatory intervention, in certain cases there is nonchalance to regulate. Take, for example, the violation of intellectual property rights. Our markets are flooded with illicit products, which are both counterfeit and lookalike. Large numbers of products are smuggled into the Bangladesh market, be it consumer products, be it electronics, even pharmaceuticals. The government is losing an estimated 600 crore simply due to illicit products in the consumer goods sector. Yet, no regulator is taking ownership of the problem, and there is a lack of enforcement. There are no corporate governance regulations for private companies. The corporate governance guidelines issued by the Securities and Exchange Commission obviously applies only to public listed companies. There is no monitoring of returns filing by private enterprises. There are no disclosure requirements whatsoever, and the absence of a basic corporate governance framework has also contributed to calamities in our banking sector. The regulatory framework for e-commerce is underdeveloped, even though now companies are spending on an average 6 to 8% of their revenue in the digital market. Digital marketing, advertising, social media marketing, all of this, sale of goods through digital channels is taking over in Bangladesh. There is also no regulation of advertising in any form, and hence no check on negligent or fraudulent representations by manufacturers. A staggering 80,000 crores in non-performing loans is testimony to the corruption that underlies regulatory inconsistencies. Monetary corruption is now factored into the cost of compliance in Bangladesh. Corruption can also take the form of incompetence, where the regulator is simply unable to appreciate an issue. A small example is the issuance or renewal of import registration certificates and export registration certificates, which are processed by the Chief Controller of Import and Exports, called CCI. Concerned officers at CCIs are not familiar with the different types of corporate entities, and there have been cases where these officers have insisted that companies change all their documentation to classify them as a joint venture company simply because that is the only type of entity they are familiar with. Our revenue laws incentivize its officers to detect evasion or any other offense. This has led to an unhealthy practices of exorbitant claims or VAT demands on account of evasion or irregularities, in many cases which do not have any legal or factual basis. Under our tax, VAT and customs regime, an assessee is obliged to go through the hearing and appeal procedures under the Revenue Authority and then finally appeal to the High Court with a 10% appeal deposit. What is even more alarming that the 2012 VAT Act proposes that this appeal deposit be given in 3 stages, which would in effect amount to a 30% deposit. When we see VAT demands and revenue demands, which are of exorbitant sums and which often lack any proper accounting or legal basis, it begs the question, what financial burden are we placing on businesses when we would require them to pay 30% of those demands simply to have a legal right of redress? And this brings me to the most important part of our legal framework, which is the right to redress or a proper remedy for illegal, irrational, or unreasonable acts of a regulator or even of a regulation. An independent judiciary is the bedrock of good governance and the very foundation of rule of law. While we have constitutional safeguards on right to property and right to trade, do these do enough to curb the regulatory excesses or irrationalities that we face in our day-to-day businesses? Do we have effective legal remedies under our laws and our constitutions? Are our judicial procedures sensitive to the essence of time in commercial matters? Is there perhaps a need for separate or specialized commercial courts and tax courts in Bangladesh? These are just a few questions on our judicial procedures and our legal framework that I would leave our panelists with. If we can't simplify our processes, develop capability, and improve the attitude of our regulators, and are not able to avail effective legal remedies even in courts, then we will not be able to provide the stability and certainty required for doing business in Bangladesh, and we will be depriving ourselves from unlocking our future potential that has actually termed us and labeled us as the new Asian tiger. With these very few basic and summary thoughts, I hope I've been able to sketch actually the many legal and regulatory nuances that come up in doing business in our day-to-day lives. And I leave these thoughts with our panelists and with all of you, and look forward to the insights during the sessions of the day. Thank you.